man, if you read the press, it sure looks like Blake Lively has won and Justin Baldoni missed deadlines and lost. Well, that's not the case. And we got Ron Zambrano here to break it all down. Welcome to Popcorn Planet. I am Andy Signor. So glad to have Ron Zambrano back. Ron, I also got to give you a big congrats. I heard you won a huge 7-figure case for an employee who was against, I guess, her manager SA'd them. It sounded awful, but congratulations for always being ahead, doing these amazing victories for these victims out there. Bravo, sir.
Thank you. Thank you so much. Yeah, it's always an honor to represent these women who are victims and to give them some type of justice, even though they can't ever go back to where they were. But we're really proud of it. Thank you.
Well, I like to share your wins too, because obviously you know what you're talking about with this employment stuff, especially out in California. And I want to start with, you've done a lot of these cases. I've been kind of blown away by the media basically lying, in my opinion. I want to get your 2 cents, but all these articles in TMZ make it sound like Justin just accepted his fate. It's over. He missed a deadline to appeal a judge's ruling that dismissed. It's all over. People magazine after his missed deadline. Rolling Stone missed deadline. Basically, it's over. Like, this is all over. New York Post, page 6, ABC News, everywhere, all over the internet. It's Justin Baldoni lost. He failed to do this. It's kind of shocking. As you look at this, though, you went through the actual judge's rulings here. This isn't true, is it? The reality is he didn't actually miss a deadline. He still can appeal. Can you? I guess I've finally actually understand what's happening, but can you perhaps explain it better to the audience?
Sure. So in order to appeal under the federal rules of appellate procedure, there's something called Federal Rule 4. And typically, in most even state courts, what has to happen is not only do you get the order that the defense or whoever lost, gets kicked out or gets a case kicked out, then you have like this process called entering judgment. You got to get a judgment signed, and then you get to enter judgment. And then the clock doesn't start ticking to file the appeal until the entry of notice of judgment. And yes, it's very, very complicated, probably overcomplicated for purposes of how simple it is. But basically, there's this underlying kind of like practical rule that says, listen, the 30-day deadline really starts from the date of the order that kicks your case out that you want to appeal. But there's like this other type of like mess of this. Well, what about notice of entry of judgment? So the judge said, listen, we just amended the federal, well, not we, but the federal rule of appellate procedure was just amended. I can make the call that I'm going to wait on having a finality of this particular issue until I rule on the subsequent motion for fees that we've already talked about, like the hundreds of millions of dollars. And so Judge Lyman said, you know what? For purposes of just judicial resources and clarity, I'm going to rule now that we're not going to start the 30-day rule, the 30-day timing for purposes of filing an appeal, the window, because you can't file before you're supposed to. But the 30-day window does not start until I, Judge Lyman, rule on Lively's motion for fees connected to I, Judge Lyman's order agreeing with Lively dismissing the cross complaint. So technically, there is no delay. I mean, excuse me, there was no deadline to miss. So right now, the deadline doesn't exist now. It won't even start. The 30-day window won't start until there's a ruling on the motion by Lively in connection with her work, which is this really big number. And until then, Baldoni's just kind of just waiting.
Right, as it says here, and people can look it up themselves here on page 205. But enumerated before an appeal from the judgment has been taken, the time to file an appeal runs for all parties from the entry of the order disposing of that motion rather than from the entry of final judgment. And so one of the motions effectively pauses the appellate clock as a motion to alter or amend the judgment. He goes in and explains it multiple times for all parties from the entry of the order of disposing of the motions or fees. So basically the clock hasn't started for him to be able to appeal. It starts after they sort out what the fees are, correct?
Yes, and he actually says it quite directly in his very last full paragraph. If you go down, there it is. It is therefore ordered. So the second paragraph, it is further ordered under Federal Rule Civil Procedure 58E that Lively's, you could read it, I'm sorry. But that's
Lively's motion to treat her pending motions for fees as motions in Federal 559. The Times motion seeking entry partial judgment denied, moot, given the court's final judgment. So Again, he
Right.
can still appeal this. This isn't over. And one could
Yeah.
argue, given that he is also just hired Alexander Shapiro, who's clearly appellate court and very established lawyer, one could assume, well, yeah, he's not going to keep arguing with Lyman on this. They could have other potential plans in the appeal, right? That wouldn't be the time now anyway, correct?
Yeah, it wouldn't be the time now anyway. So there is a appealing too soon where the Court of Appeal can get a notice of appeals. Like you're not even supposed to be here because the appellate courts are they're super strict sticklers for procedure. So again, the 30-day window has not started until there's a ruling on the motion for fees. And again, we're talking with very sophisticated people at the top of our profession at a national level. This is not stuff they will just forget about. If they thought there was an actual deadline, they would have filed the notice of appeal because it doesn't cost anything. You don't have to argue it. I think it's like a 2-page form and like a fee of like $700. So this isn't, if he had missed it, it's news. But according to the way I read this ruling, it's the judge is like, listen, we're going to the 30-day window doesn't start until I rule on the fee motion. That's it.
Right. They have time. Well, I guess
Yeah.
what's scary to me, and as someone who's still facing her wrath in my own subpoena drama, it's just wild to see how the press just ate this up. It's seemingly all just almost like Blake PR, just spread some sort of a soundbite that everybody ran with. And then a lot of other people out there just setting up this narrative of, well, all the reactionary Democrat and right-wing content creators who spent months participating in the smear campaign against Blake apologize and admit they were wrong. Of course not. But it's like, that's not what happened here. We're still in the thick of it. As someone who's represented a lot of regular people against powerful celebrities, is this something you see often where they're using these PR tactics and sort of power plays to play the media PR spin rather than actually what's happening in the case?
Oh, absolutely. It happens quite often. I'll refrain from names, but yeah, and it's very, very frustrating because the people surrounding these celebrities are invested in those celebrities' success, and they will pull all levers in order to frame the narrative, at least in public, for purposes of public relations, because that's really where they live and die for purposes of their living. So if they can somehow spin something so that they get a push, right? A really good push of positive news their way, even though they're not really being all correct, it's good for the brand. And if the brand works, then the investors get a return. If the brand that is partially tarnished starts to become untarnished, right? Like the poo on it starts getting wiped off. But this is going to be, he can still appeal. And what are they going to do next? Like, oh, we messed up because again, the window hasn't even started yet.
Well, it is wild because as someone who's still facing the subpoena, it's interesting. The scariness of it, of just sort of the control they have. Recently, also that was dropped was this sort of, I guess this is the initial disclosures where they reveal who sort of they're going after, who has this sort of information. And it's a very long list that features all the obviously defendants, et cetera. But then it goes down. Perez Hilton's on here. Candace Owens is on here. Colleen Hoover's on here. Even Shersty, I think, was on here. It's just a huge list of people that's, they even wrote Claire Abe, parties who may have information for them. And it's just wild because I'm not on here, Ron. I'm not on here, yet they are still out there, not only trying to, get me to give information, they're now trying to go against Lyman's own rulings to basically change the time frame of which I'm supposed to now pursue my conversations of news gathering sources. Are you surprised that they're still out there sort of playing these tactics? And is this right in your mind?
So to answer your first question, no. It is when celebrities do, decide to fight back, they use their money and influence to get the attorneys that will do what they tell them to do. And this is really what's happening to you, I think, is a terrible shame because it really chills other people trying to report the news, which is what the process is not supposed to be used for. And I am not surprised. But for purposes of this is something you can use, Andy. For you, saying I don't know why they're still asking for my stuff. They haven't even identified me as someone who may know something. And I think that might be powerful.
Yeah, I hope, and I'm wrong. I'm wrong. Sorry, Shersty was not on this. It's another. There's so much stuff coming in. I mistook. There's another story. Stay tuned. She's not on this, but a lot of people are, and it is very weird that I'm still being Taylor Swift somehow on there. She's bringing her in as someone who has knowledge, even though she's mad. Justin brought her into the equation. Ron, there's just so much hypocrisy and nonsense in here. It's wild. Speaking of nonsense, while I have you, I did want to get your thoughts because we have one more topic just quickly. Stephanie Jones, Jennifer Abel, this case is still going, and Jennifer Abel just put her sort of amended complaint in. And in here, there's a lot of stuff, just for sake of clarity, thanks for Kim's notes. I have some sort of summaries here because a lot's redacted, but she talks about how a lot of this is the phone that was taken, right? Jennifer Abel's phone was taken, which was all those texts were used to basically start this case. And she's now, suing Samantha Jones, et cetera, saying, well, this was wrong. And she's mentioning the fact that, yeah, they not only was, well, I guess the debate of whether this was a work phone or not, I'm curious your employment legal, mind. She's talking about how, communications were immensely private about her and her sex lives, about her fertility issues with her husband, so much private stuff, as well as during the case, et cetera, personal photos, all were being dispersed not only through Jones, but to Blake, and et cetera, and the press. They've now been captured for this relegated litigation. It's been handed in through the litigation. Like, how is this allowed? And do you think this is going to come back to really hurt Team Blake and Stephanie? They used the fake shell corporation, as you remember, it seems, the Van Zam stuff. How is this not a bigger deal for the judge? And do you think that she could potentially finally get justice in this? Or because it's a work phone, she's screwed and they were allowed to do everything they wanted with her personal information? How is this okay? What are your thoughts?
Well, I immediately remember when you and I first met for the documentary out in the valley here in California, and I was commenting like it's really weird that they have someone else's phone. So when it comes to work phone and privacy, there are some very specific notice requirements for someone to be unknown. So when I give an employee any electronic device, I have to, if I intend to like use anything there, you have to tell them like, listen, I'm giving you this, but everything that you put in here technically belongs not to me, but to the company. So, and it has to be in writing. And if it was in writing and it was acknowledged by Abel, then even though she put personal stuff there, she was on notice and she shouldn't have done it. That doesn't mean that the company or here, Stephanie Jones, can use it however she wants or give it to whoever she wants. She still has to use some type of discretion and judgment. And if she gave, for instance, the entire electronic contents, right, a photo digital copy of the phone, which I think is what happened because of the way the CRD complaint was quoted and was put into the complaint, and that was just given to Lively, that is absolutely a violation of Abel's privacy rights, right? Like her stuff about her husband, her stuff about all her sex life, all that stuff is not stuff that was needed for purposes of the underlying litigation. And if everything was just handed over to a third party, that is defamation. That is absolutely an invasion of privacy. And if you didn't get permission first of kind of extracting that information, and if there was no notice, like, listen, your phone is going to be pretty much like, don't use your phone for personal purposes, because, if that notice wasn't there, Stephanie Jones is big trouble, big trouble. And potentially, I think, Lively, because they should have known. They should have asked, like, wait a minute, how do you have someone's personal stuff? And if they didn't take reasonable steps, because you and I would have asked that, like, whoa, how is it that you have such intimate details about a third person that I don't even know? How is it? You as a reasonable person, I don't know if I want to have this. I don't want to use this. I don't want to read this. It is something that is a very, very delicate situation. So it's all contingent whether Stephanie Jones, which I've heard through rumors, probably isn't the best boss.
I've heard those too.
Crossed her T's and tossed her I's with regard, and dotted her I's rather with regards to doing these really formal notices, and not just an NDA. It has to be like, I'm giving you a phone. Here's not a waiver, but I'm giving you notice. Whatever you put in this phone, I'm going to have access to. That's one. But even if she had access to personal stuff, giving it to a third party, that could in and of itself be a basis for defamation, in my opinion.
I love it. It's interesting you brought that up because there's also another mention where they bring up Van Zam. The same day the lawsuit was filed, Jones warned a departing employee not to work with Abel because her business wouldn't be around much longer, sort of implying these sinister plans. And then also, as the document sort of goes in here and explains more, I have a summary that's easier to find, but We'll go through this tomorrow on the live as well in more detail, guys, so make sure to subscribe. Lively parties likely anticipated or were told directly that the New York Times would not traffic in stolen communications under these circumstances and needed the color of the law. Jones worked for their part, wanted to insulate themselves from legal exposure, hence the enter of Van Zam into now the lawsuit. So again, I'm still shocked this isn't a big part. Final thoughts. Do you think this will finally start getting some attention, or is Lyman going to not see this as relevant?
Well, Lyman, I don't think Lyman has a choice because the lawsuit is now consolidated and related to the larger story that started with Lively's lawsuit. So he's going to have to be, what the claims include, these allegations, and is absolutely relevant. Now, it depends what Abel is going to do. If I was Abel's attorneys, I would think about getting discovery to figure out if it was actually communicated and how it was communicated to Lively and who Lively repeated it to, in order to include Lively and anyone else there as part of the defendants for the defamation and invasion of privacy claims. That's something I would do. It's a lot of work and you're dealing with a lot of things, and you know how it's like in litigation of this, but it might be worth it. And I would not be surprised if Friedman is not, helping with these thoughts for purposes of egging these people on, because their discovery just started, or it's not as far along as the other.
So many movie pieces. I always appreciate when you make time to come in, and we'll have you back. Please, guys, follow Ron Zambrano when you can on West Coast Trial Lawyers is where, if you ever need them, if you got an important case. Thank you, sir, as always. Guys, make sure you hit that subscribe if you haven't already. We'll have him back and we'll give you more insight. We'll be live tomorrow with lots more to go through. So if you missed it, please join us. Hit that thumbs up, etc. Leave your comments for engagement and stay tuned. What are your thoughts on all this? I want to hear them down below. Thank you guys so much for watching, and stay tuned for more here on Popcorn Planet.